Hello, everyone. Welcome back. It's Friday, so it's another webinar, another free webinar. Thanks for tuning in. I'm joined today. I have Will Graves in the studio. Let's add him to the stream. Hello, Will. How are you doing today?
Hey, Rilus, pretty good. How are you?
I'm doing good.
Good.
So it's good to be back. So as Will knows, I was in Wyoming earlier this week. I was still working, but I was hanging out in the cool weather at my sister's cabin. So she invited me to come to her place in Star Valley Ranch, Wyoming, and I had enough airline miles saved up so to get me and my boys there. So that's what we did last week. So that's what has inspired today's topic in part. So I told you today we wanted to continue to talk about cabin trust or to talk about cabins in general. So what to do with them. And this is a topic that we've talked about once already, haven't we, Will?
Yeah, a few weeks ago, we kind of started the conversation anyway, and it's nice to add to that.
Yeah, so what I want to do, I want to build on that conversation about cabins, and I want to talk about Dynasty Trust as well. I'm going to bring that into the mix, and LLCs. So today we're going to bring all those things together.
Okay.
So I have a new PowerPoint, and I've been enjoying these webinar Fridays, and it's nice to go live. It's nice to take time to think about the hot topics of the week, or just what's on our minds, the things that we're discussing as attorneys, and that's what we turn into a broadcast. And what I've been doing lately is I've been updating the visual materials, the PowerPoint that we use to have something to use on the stream, and also for us to use when we're meeting with clients discussing these issues. So I have some new PowerPoint as well that I want to go over today.
Sounds good. I view this kind of like a learning activity for myself and the viewers. So it's kind of like what we do at the office, but now it's live for everyone to.
Right. We might as well have the conversation live so other people can benefit from it. But these are a lot like our different attorney meetings, aren't they? What we call our admin meeting.
Yeah.
Where we get together and practice law. That's why I say that's my day to be a lawyer. Make legal decisions. It's really fun. So a couple of house cleaning things I want to get into before we get into today's topic. Another topic that's come up as of late, and it's probably going to come up more with the low interest rates, is people refinancing. So what should people do, Will, in regards to the revocable trust that they're refinancing?
Yeah, well, a lot of times it's a matter of working with their lender, and most of the time the lender wants to refinance the house in their individual names, which requires them to take the property out of the trust and then put it back in when they're done. Certain companies I've found have been able to do that with the house still in trust, but that's not as common, I don't think.
Right. So if your house is owned by a trust and you're going to refinance, your bank may want you to either move it out of the trust to do the refinance, or they want you to do what they call an attorney opinion letter. So recently we got a request for one of these attorney opinion letters. Now I hate doing them because we'll give all the bank that exact information, but sometimes they get caught up in they say who's the settlor of the trust, and we use the term trustor, or little things like that, or we give them all the information, but maybe they want it in a little bit different order. So we spend more time doing those opinion letters, going back and forth with the bank. Yeah. So in order to be efficient, for our clients, they don't want to pay us to spend a lot of time because we're going to have to charge more money for it.
Yeah, and there's liability involved in those opinion letters. I had a professor in law school who, did one of those opinion letters for free for a client and ended up getting sued over it. So, I think that sometimes people think that it's just really easy for an attorney to write down an opinion letter and give it to them. But, we have to be very careful on how we research whatever it is that they're asking for opinion on and not go too broad. So
what we would rather do is just transfer the property out of the trust so you can refinance it. And then after the refinance is over, put the property back into the trust.
Right.
Now, as you were saying, some title companies will do this. So you you just got to be careful after you're done with your refinance to get your house back into the trust. And usually what I recommend, if you know you're going to refinance, come see us before then, or just move your property out of the trust. Because what happens is people are on a time crunch. Sometimes they don't find out about this until later. They're halfway through their refinance, and then the bank calls them and says, "Here's what we need, like right now. We need this within 24 hours." And as much as we'd love to jump for everyone, we can't always do that. We can't always give things, we can't always do a 24-hour turnaround time. So something to be aware of. If you're refinancing, it's best to be, like I said, just move the house out of the trust before, or talk about it with your lender right away. We have a trust. Can you move it out of the trust for us? What do you want us to do?
And a lot of times those lenders will move it out of the trust for you, but then they don't help you putting it back into the trust, which is irritating. But that's when a lot of our clients come back to us for help putting it back into the trust.
Yes. Oh, what happened? I shared my screen, but I lost my
Yeah.
There it is. Okay, so this is what I want to get into. So let's do a quick overview of what we went over last stream. We went over what to do if you're the executor. So define the players. You have the decedent, the fiduciary who's in charge, and the beneficiary. So what do you do if you're the executor? Number 2 is, what are the assets? What stuff's out there? What controls the assets? So what documents are in play? It's either if it's in the name of the deceased person, it's said to be in their estate, or it could be inside of a trust. And then let's see here. So the estate is controlled by a last will and testament if they had one, or intestate succession if there's no will. Okay, so you need to, number 4 is you safeguard the assets and start accounting. 5, collect all the assets, determine and pay valid debts, and then share accounting and divide assets. So it's that easy, isn't it, Will?
Yeah, that's a pretty good summary right there.
Sometimes those steps, obviously it's not as easy to determine valid debts, or the accounting, there could be more to it, but that's kind of the overview and the roadmap.
Yeah.
Okay, let's get into cabins. Should we get into cabins now? Vacation properties.
All this talk of cabins is making me want to buy one with some investors and get it in an LLC or some sort.
Yeah, that's gonna be our next thing. So
yeah.
Whatever, whether it's a cabin, vacation home, this is a topic that's been coming up. People say, what should we do with this? We have this beautiful place. We want it to be preserved in our family. And if you watch some of the other broadcasts, they might be kind of negative, or they might seem kind of negative when we're just telling all the bad things that could happen, right? Just saying why it's a bad idea to have multiple owners. It's our jobs as attorneys to explain all the bad things that could happen. So I think that leaves us a little jaded sometimes.
Yeah.
So what I was thinking about this morning, thinking about topics for today's stream is all the best things are the hard things, right? Just because it's challenging doesn't mean that we should shy away from it. And exactly. I guess spending time, in a beautiful property, it's pulling me back into that. It's like, all right, what should people do if they own a place like this and they have multiple siblings? What can they do for families to get along? Okay, so LLC, that's what you mentioned. So the cabin, you probably want it in an LLC, especially if you're renting it out to other people and other users. If you're going to let other people, if you're going to Airbnb it, is a popular thing right now. Let other people use it as a vacation rental. That's what you were saying, right, Will?
Yeah, I think that would be a cool thing to do to sort of make it more cost effective if you're not using it 100% of the time. Depending on how often it gets used, it'd be nice to rent it part of the time. But that, then the LLC is important because it could limit your liability in case of a lawsuit from a potential renter.
Yeah, let's talk about the pieces of an LLC. So the first part is you have an LLC. They call it the member of the LLC.
Right.
But people also say they say that they're owner of an LLC.
Yeah.
It's just like if you're if you're the owner of a partnership, you're a partner.
Right.
If you own an LLC, you're a member. Now, usually we want that owner to be a revocable trust. So as part of the estate plan. The next piece, the manager. So what are your options for manager, Will? What can people do?
Yeah, so a manager doesn't necessarily mean the owner. So typically you get to choose between a member managed or a manager managed LLC. And the manager managed ones are where you're delegating that responsibility primarily away from the owner so that
or it could be a single owner.
Right.
So if there are several kids or several beneficiaries, you could have all of them be members or owners of the LLC, but reduce the management down to a single or maybe two members to manage it, two managers.
So that manager is kind of doing the day-to-day business affairs of the
yeah
business. Yeah.
And then the other part, operating agreement. So are operating agreements required, Will?
Not in Arizona. They're not required, but highly recommended, especially for something like this, because this is going to govern the affairs of the business.
Yeah. So I was going to ask you, what is an operating agreement? How would you describe an operating agreement?
Yeah. So that's going to, it basically modifies the default rules where some of those default rules aren't going to be advantageous to a particular person. So this is going to say how much capital contribution you've put in, what the buyout is, who has the right to bind the contracts and liabilities of the company.
Yeah, it's going to clarify the terms of it. Now, we do a lot of LLCs for the single members, where usually just the trust is a member and people are creating it for themselves.
Yeah.
So it's still important to have an operating agreement because it shows that they're treating it as a business and how it works. Now, when you have multiple members, multiple beneficiaries, this written agreement becomes that much more important. Saying, what are the rules? How is this going to work?
Yeah.
Okay. So the LLC, it should be owned by a revocable trust. This is our flow chart for a continuation trust, which is a trust for a married couple. Above this dotted line is why they're both alive, so the LLC would be owned by their trust. When one of them passes, it's still owned by the trust for the surviving spouse. And then here's where it gets interesting after they're both gone. So we've talked in some of our previous things about subtrust. Subtrust, how would you describe a subtrust, Will?
Yeah, well, there's different types of subtrust, Dynasty being one. Our most common that we've been talking about in previous episodes is our age trust, where the trustee is holding money in a trust account after the deceased has passed away for the children to reach a certain age. So it's kind of just a trust that gets created after the donors have died.
In the trust, I would say probably the most simple definition is a subtrust is a trust created by another trust.
Right. Yeah.
So what we're looking at here is after both of the trustors have passed away, or if is a single person after they've passed away, and their trust splits into 3 different dynasty trusts is what this is showing.
Yeah.
So now whenever my recommendation I think good estate planning is about options. We want to provide good options for the future. We don't know what exactly the future holds, but the more options you have, it helps things. Now, I don't like to specify usually what's going to happen with the assets in trust after the death of both trustees. What I mean by that, sometimes people will say, I want to make sure this house is sold and all this, or can you think of other examples, Will?
In law school, we went through some of these, where you could be very narrow and say this trust can only be used for, maintenance on the house or the business of a shopping mall, or what you could get very particular, I think.
Yeah, but we want to provide more options. So, so generally, we don't. If there is no specific gifts, and the trust owned an LLC with a cabin in it, this trustee here, what they would first do, what we would do if we're representing the trustee, is first we would see if anyone wants it. It would say, does anyone want the cabin as part of their share?
Yeah.
And maybe the other kids aren't interested in it. And sometimes it happens that way. And if there's, whoa. So as long as there's enough assets to equalize, then that's a good option. So let's say, just to make easy math, let's say this is a $3 million estate with the cabin being worth $1 million and $2 million of other liquid assets. So if this middle child said, "Hey, I want the cabin,"
I'll give you their.
You said, "Cool, we don't care. We want the money."
Right.
Then there you go. So that's an easy distribution. That transfers the property to this one single owner. Yeah. And so sometimes we see, parents will want, or someone designing a plan, they'll say, "I want this to go to all three of them or to multiple people," but sometimes they don't want it, right? So that's why I'd rather let them choose.
Right.
So just, we have all the assets in the trust, and with specific things like real estate and businesses, we can ask the kids if they want it. And a lot of times we are able to work out where just one of the kids want it, or maybe two of the kids want it. Okay. Now, what if all three of them want it? What if we want to share it? What if they want to share it? So I think the best way to do it, if all three of the kids or multiple beneficiaries want this property, is each of their dynasty trusts could own, so they could be members of the LLC. Now the manager, so again, who's going to be the manager of this type of situation? If we have three people sharing an asset, or just whenever you have multiple people sharing an asset, you get potential for liability, potential for lawsuits, don't you, Will?
Yeah, that's a risk.
And I think that's what we highlighted a lot on our last stream about this topic. Yeah. We talked a lot about the problems, but not as much about the solutions.
The benefits and solutions, right?
But the way to deal with this is to think of who is the manager is going to be. Now, again, I wouldn't want all three of them to be the manager, because that's no tiebreaker, right? I had this recently, just the other day, clients where they want four of their kids, all four of them together.
Oh,
I really think it's a bad idea, and you're going to hear me say it over and over, and we're even going to put it in writing that it's not our recommendations, but yeah, that's absolutely what you want.
At least with three here, you could have 2/3 would have a majority, but whereas four, you could just have a split, which would lead to conflict.
Yeah, that is a good point too. So when you're talking about managers, odd numbers are nice.
Yeah.
For reason.
But there's still the possibility of conflict if all three of them can't come to a compromise. So
this written agreement is what's going to guard against that.
Right. The operating. So
if we can clarify in a written agreement of how the property is going to be used, and we have a manager who's following those instructions, that would be the best case scenario.
Yeah.
So for people, if they have a property like this in their family, something that they do want to pass on, let's back up here. So they can create that LLC now. So that's something they can create the LLC. And if it's something that they want, multiple members to be able to use, they can do that within the written agreement. So in the operating agreement, they can designate what are the rules for the LLC. What are the rules for that property?
Yeah.
My other advice, I would say, you have to do the written agreement, but you actually have to follow it. That may seem obvious, right? Does that seem obvious?
It does, but I can see your point in that some people just do it for the formality of doing it and never look at it again.
Yeah, so you have to make sure that you treat it like a business. So like similar to Airbnb, I think would be a good setup, where if you're renting it to other people, there's a system in place for who pays for something if it breaks, all of those things. But if one of the members goes there and breaks something, then you need to hold them accountable and treat them all equally.
Yeah.
Because another thing we see, Will, is we see beautiful contracts and then people just not follow them, right?
Yeah.
And then you get it's like, what do you do if the course of dealing for years and years has been different to what the actual written agreement says?
Right.
So, and then when I feel like we have to crush dreams a lot too, when it's like the wishes of the deceased, like I promised them that I would let all 200 of the grandkids be able to use this. That was one of the scenarios we saw where there was over 200 beneficiaries now because they want all their heirs to be able to use that property. And with the kids and grandkids, there might have been some great grandkids at this point.
Right.
It totaled over 200.
Wow.
So I guess what I want to get at today is it is possible to manage these properties. The way to do it is with, a written agreement and the management, who's going to manage it. And then the structure to have it in, you want it inside your revocable trust to avoid probate. And then really you want a dynasty trust. If it's something of value, we start recommending dynasty trust whenever a single beneficiary is going to inherit more than $500,000. So that's when we want to put a layer of protection around theirs.
And that dynasty trust is like a subtrust that can continue living, and they can continue managing their own trust even into the future, which has some benefits to it.
Yes. So that's right. It is another trust. So let's remove that. Let's see. Where did I go? Nope. I want to add
of the cabinet. Oh, there you go.
There we go. I wanted to remove the screen share.
Yeah.
So that's what you can do if you have a cabin. So we call our first meeting the personal family legal session. That's a chance to meet with Will, myself, or Anna, one of the attorneys at Dana and Associates. We'll go over describe the process. Will, describe what happens in that personal family legal session.
Sure. It's kind of like the initial consultation where you call our office and we'll email you or mail you even a personal inventory, which is something for you to fill out, saying your name and if you're married and if you have kids, and kind of just a very basic idea of what your assets are. And so that's what we would use during that first consultation.
Yeah, that way we can have an efficient meeting. That way we can start giving specific advice like right away.
That's why we stress that we'd like to receive
you have kids, how they are, what assets you have, the value of them. So in that personal family legal session, there's a lot of value where, so they fill out that information. We meet with them, and one of the first questions we ask is, "What are you looking for?" Right?
Yeah.
And sometimes the emphasis is, I want to make sure I name guardians for my children. Or maybe it's a cabin that they want to protect, like we're talking about today. But generally, or what do people usually say, Will? What would you say? What would you say the common answer to that question is?
I think that my clients, for the most part, are looking to not create a headache and a hassle for their kids if something were to happen to them. And they want to be protected in case of an accident or incapacity in their old age. And so that's what we really structure.
It's usually that first one, right? Usually people say, why are you here? Well, I don't know. I just don't want to create a mess, right?
Yeah, I just don't want to. Yeah. I want it to be super easy for my kids. That's what I hear a lot.
And then we start clarifying what kind of messes there are and how to avoid them.
Yeah.
The main one being probate that we help people avoid.
Yeah.
So what is probate, Will?
So I always use your very simple, quick definition, which I know we could expand on, but that's where we're taking title of an asset out of the name of a deceased person through court. So you'd have to go into court to remove, say, a house out of the deceased person's name into whoever it goes to, based on a will or intestacy or a trust.
Yeah, so good. That's I think like the dictionary definition. It's a judicial process to change title of an asset out of the name of the deceased. So that's the main thing that can trip people up. But then it's nice to have their specific information when we ask what they're looking for. Then we'll see what assets they have, see what their family dynamic is. It could be what we call a his and hers children, or they each have children from a different relationship, or it could be, there's all sorts of things that we could be looking at in how we make our recommendations. But towards the middle or end of that meeting, we can give you a recommendation of what we recommend, of the type of estate plan that's right for you, and then quote you a flat fee for it. And then if you're ready to get started, we'll take a deposit right then and start designing your plan. So that's the personal family legal session. And then what happens next, Will, after we design the plan and in that first meeting?
Right. So that's when we would email them a fee agreement and a drafting review summary of what we have decided to how to structure their estate planning documents. So then we'd want them to sign that and return it to them. And then after that, we have another meeting.
We ask a lot of hard questions, right? And we push for answers. Yep. The reason we push for answers is because it doesn't get any easier, right? If you don't know today, you might not know tomorrow. But
a lot
just
of people
started
too. Your first instinct is usually what you go with.
Yeah. So that's why we want people to start the process, but we want to give time as well, right? We know they're hard questions. We want some time for reflection and for you to make sure that it's the right people or right companies for your plan, for your family. And then, so the next steps is you'll get a chance to approve that information. You get it about a week later, everything we decided in that meeting. And then what happens after they approve it?
That's when we draft the documents, the will, the trust, the powers of attorney, the digital asset trust, and send it to them in an email to review.
Yeah, so then you'll receive a copy of your legal documents, and then we schedule the attorney review meeting right after that. So right after you get the documents, we'll get on another Zoom call, and we'll look at everything together. Or in person, we'll still look at it on the screens. That's how we're doing it in person, right, Will? We're doing kind of like the hybrid style.
That is. I did one of those the other day, and it was interesting because although we were in the same room wearing masks with a little shield between us, I still used the big TV to go through each form with them.
Yeah, but the point of that meeting is to review the documents together to make sure they meet your wishes. So that's another chance with the attorney to say, are you sure you want to name this person, or to clarify what those rules are, and make sure it meets their wishes. And then at the end of that meeting, we finalize all the documents. So if they're approved, we mark it as a final document ready for signed. Or sometimes they need more time on something, or sometimes there's something that needs to be updated. So we'll mark that as another draft, and we'll do another update until it's a final. And then what happens after they've marked everything final?
So that's when we schedule them to come into our office to sign everything. So they would come by, we'd put a sticky note on their documents. We'd have the witnesses there. They'd want to bring in their driver's license so we can notarize their documents. It's their signing meeting.
Yeah, so that signing meeting, it's really just signing, right? Because we've already gone through all of the documents before. We've gone through the moving pieces. They understand them. They've had a chance to ask all their questions before. So at this point, it's just the formality of inking it, putting the ink there in front of the notary, in front of the witnesses, get everything signed. And then what happens?
Okay, so that's when their will and their trust are executed and finalized and signed, so they're valid. After that, we would
so they become valid right then. So that's the point when they're covered.
Right. So that's kind of a crucial, step, getting them in and getting that stuff signed. So after that, we would mail them the original documents in a binder, and they'd also get an email invite to our digital vault called Everplans, where we've kept a scanned copy of their documents in a website where they can get access from anywhere.
Yeah, so they'll receive the originals by paper and then a digital copy via we call it the digital vault, powered by Everplans.
Right.
So they get all of those, and then there's one more meeting left, or what's left to do at this point.
Yeah, well, yeah, the funding of the trust meeting is a very important meeting, and
Yeah,
that's
funding. So we call the final meeting the trust asset coordination session. So this is a meeting with the attorney while you have the copies of the legal documents. So we should talk about the funding earlier in the process. We would do it in that signing meeting, but I found it was too much information at once. I felt people weren't retaining, the important steps of funding their trust, getting their bank accounts into the trust, naming the proper beneficiaries on life insurance and 401ks. So that's why we created that separate time to focus on those issues and to talk about it when people can take action. So right after that meeting, they can call their bank and they can go down there and make the changes.
Yeah. It's important that they know that everything's not just because the documents are executed, their job isn't fully done until they use the trust to make it a beneficiary or owner on bank accounts. So we have a meeting that is very specific to the client and who their children are, who their beneficiaries are, what their trust is doing for them.
It's not going to focus well on the binder. Here we go.
Oh, there you go.
But I say it's my Vanna White moment. I get to show the features, everything that's included, and make sure people understand how to really utilize their plan.
Yeah.
So that's like I said, we started that process because I saw a lot of people were missing it. We want to make this as easy as possible for you to have a complete plan. We get people that call our office sometimes, wanting a price quote, and we tell them we're definitely not the cheapest. If you're looking for the cheapest, you can find elsewhere, but we provide a very comprehensive service, and we're definitely not the most expensive either. We have very competitive rates, but it's important to understand the whole process of that. It's not just we're slinging a document at you to sign. We're guiding you through the whole process. So, any closing thoughts today, Will?
Boy, no, I don't have much. I don't have much to say. I guess I've given all my hidden nuggets of advice in previous meetings, so I don't have anything original today.
Yeah, but it's Friday already, huh? So you're already out of all those that wisdom.
Yeah, I've already used it up for the week.
Yeah, you gotta take some time off and regenerate some more.
Yeah.
Thank you everyone for joining us. We'll see you next week. If you have any topics you'd like us to discuss, leave them in the comments or send us an email, and take care.
All right. Thanks, Rilus. Thanks, everyone. Take care.